Speaking of crimes, I have repeatedly had to face many situations where people have justified certain actions as being a state of necessary defense. Today with Nikita, we will touch on this topic and try to explain what it means when a person must bear responsibility and is subject to punishment for a certain action, and when they are exempt from such responsibility and why. Hi, Nikita.
Hello, Vladimir. You've touched on a very interesting topic of necessary defense. Indeed, in some cases, if a person is in a state of necessary defense, then the liability of this person, it will be excluded. But for this, of course, certain prerequisites must be fulfilled.
Yes, yes. I have had to repeatedly participate in the defense of such persons when determining the state of necessary defense during actions in a state of necessary defense. And this institution, it so to speak, contains a certain structure for qualifying specific actions. First of all, of course, it is necessary to establish whether a person is in a state of necessary defense.
Yes, correct.
Before already interpreting the actions themselves that they take, like whether the person is in a state of necessary defense. Because here, as they say, from wall to wall, the spectrum is very wide, and a person might mistakenly understand that they are in a state of necessary defense. And so here, this clear understanding of the situation is very important. Generally, why does this topic have very serious significance? Because the state of necessary defense and generally actions in a state of necessary defense, they in themselves negate the unlawfulness of the actions. When the elements of a crime are established, the objective and subjective parts, the unlawfulness is checked, and that unlawfulness is absent when there are actions in a state of necessary defense. They, in essence, justify the person's actions in this state.
Yes, of course. And certainly, since completely different cases can occur with different circumstances, then the analysis of each case is individual and special in its own way. That's exactly why the legislator provided for a fairly comprehensive system for checking the unlawfulness of a person's actions. You correctly noted that, first of all, one needs to understand whether the person was in a state of necessary defense.
Look, so being in a state of necessary defense is determined from the perspective of an outside observer's assessment, the so-called ex ante. What would any other reasonable person do in this position? A very simple example. Two people have just left a club feeling quite tipsy, heated by those alcoholic drinks, and suddenly one approaches the other and starts talking very aggressively. The person toward whom this aggressive speech is directed must now make a difficult decision for themselves. Are they truly in a state of necessary defense or not yet? Will their potential action be premature, or have they perhaps just imagined the whole threat? And since a person is in such a heated state, since the person themselves, they might even be in an inadequate state already, too drunk for this to conduct a certain assessment. That is why this aspect is very important. It is all well and good to reason when you are sitting over a textbook in a calm, quiet office, when you are not feeling fear or stress, and you make an assessment whether he was in a state of necessary self-defense or not. It is a different story when a drunk person with a knife is coming at you, and you have to do something in that situation, and you realize that running away will not help. And you do not even have to run away in order to be in a state of necessary self-defense. What can you do to justify your own actions? So that is why this aspect defining the status of being in a state of necessary self-defense is extremely important.
Yes, of course, a person must protect themselves as well as those around them and third parties. This is by no means.
And property as well, of course.
There is always a right to protect property and third parties, so to speak, their legal interests. And you do not always have to wait in some cases for the danger to have already occurred. It can be imminent. If there are grounds to believe that danger will occur very soon, then it is indeed necessary to act.
That is absolutely right. It must be immediate. Naturally, you should not wait for an attack to occur, because sometimes an attack can negate your ability to defend yourself. An attack can be so intense that you will no longer be able to do anything. I have had cases where people actually before, as in without waiting for an attack to be carried out, preventively applied certain defense measures, and they were acquitted, undoubtedly.
Of course, but people might also ask, why did the person choose to act by physically preventing the threat if they had the opportunity, for example, to simply call the police or just run away instead? And in answering this question, it should be noted, of course, that even if there was an opportunity to call for help, nevertheless, the right to act and the right to directly defend oneself or others always remains with the person.
A very important and controversial aspect. Why? Because, for example, both the intensity of the attack and the intensity of exercising one's own legal right are always evaluated from the objective standpoint of reasonableness in each case. But what is important to understand here, say, is an insult such an intense attack that, say, in response to an insult, one should use physical force? Or is it trivial in the sense that it is so insignificant that a person cannot, in relation to the one who insulted them, just go and hit them, like on the head with a club, for example, right? So everything must be absolutely reasonable and everything must be adequate. And why am I saying this? Because often people perceive things mistakenly.
Of course, because when evaluating reasonableness, one should also understand the social aspect. After all, I cannot prevent a quarrel occurring between, for example, a husband and wife. A domestic quarrel that is potentially not something dangerous, or, for example, some kind of strict, perhaps a very strict dialogue between a parent and a child, which is not necessarily harmful.
One could certainly argue about spousal disputes. In my practice, I have often encountered situations where spouses even grabbed for a knife. Unfortunately, there were cases where the husband inflicted bodily harm on the wife and vice versa, where the wife inflicted harm on the husband in the heat of the moment. But it is important to understand here that the first thing to do in this situation is to assess whether the person is in a state of necessary self-defense. Second, after that, let's say if the first stage is passed and it is clear that yes, there is an immediate threat. This threat is serious and obvious. It is not just some minor grievance. It is a serious, not just some minor insult. It is truly important, and a person should not wait for it to be carried out. He can exercise the right that is to self-defense. But what can these measures be? Let's say in the past, once upon a time, there was such a concept as proportionality. Now it certainly no longer exists. Now clearly there is this specific kind of means that you must use, which is the most lenient option for the person who is actually carrying out the threat. But let's say you really shouldn't have to choose the means, or by what specific means. You simply don't have the time to be choosing the means, and you certainly shouldn't consider fleeing as a viable means. You shouldn't consider calling a friend or calling the police as a means. That's not it at all. You must defend yourself, or you must defend your girlfriend, or you must defend your home, your property. That is, you have every right to carry out this defense. What is the question? After all, let's say if the investigation established that the person was in a state of necessary defense but still exceeded its reasonable limits, it is very important to understand here that exceeding the limits of reasonable necessary defense is only possible with direct intent. And this is a very common mistake. Let's say if a person in a fight defending themselves inflicted on the person multiple blows, either with a knife or a club or a stone or brass knuckles or something else, then even, for example, theorizing that he was defending himself, but he still defended himself excessively, intensely, and inflicted harm on the attacker. And the prosecutor's office, for example, comes out with such a thesis that he exceeded the limits of necessary defense. And here, certainly, I have had cases and successful cases where the court established that, yes, we acknowledge the excess of the limits of necessary defense, but this excess was carried out with indirect intent. Indirect intent because the person did not aim to inflict excessive harm to health, therefore, his action is not unlawful, and thus the person should be acquitted. So here it is very important to understand that exceeding is only possible with direct intent. Yes, that is already the kind of classification that the investigation provides. And if the investigation doesn't agree with this, then the lawyer must work through this issue and only then present this thesis. What else is important? Another important aspect to consider here is when a person is frequently provoked. Essentially, a situation is deliberately created, which they will then use as a justification to cause harm later on. So yes, indeed, it's some kind of maybe a minor insult like spitting, a direct insult, or something else entirely designed to make the person, the opposing side, well, let's say, come at you, or so that the other person starts talking to you in some aggressive tone and use this as a pretext to cause harm to the supposedly attacking person. So this provocative behavior it's either entirely intentional or at the very least highly culpable in nature. Depending on that, it will be qualified by the court. This will certainly have its significance and will affect both the qualification of the act itself and the subsequent punishment.
Of course. Also, one can give an example of a fight that people entered into of their own free will. And in such cases, of course, talking about necessary self-defense is very difficult. It's a debatable issue.
Impossible.
When people are fighting because they want to.
Yes. Yes, absolutely right. I hope that our conversation was to some extent useful for our viewers. Thank you very much. If there are any questions, we will definitely try to address them further if there is enough interest. Thank you very much.
Thank you, Vladimir. Thank you.